I believe in the Constitution. I believe that one case, the right case, can change the world. If you believe this too, Freedom Counsel is for you. Pursuing a major case can be overwhelming, but we provide a community of practice so that you have the resources available to support your case. My name is Warner Mendenhall, and we are Freedom Counsel. Join Freedom Counsel today. freedomcounsel.org.
You just have to flood a country's public square with enough raw sewage.
And if anybody is lying here, Senator, it is you.
Once they lose trust in their leaders, in mainstream media, in political institutions, in each other, in the possibility of truth, the game's won.
With Broken Truth, I'm John Davidson, and today with me is the lovely and talented Jennifer Kennedy Esq in California. And today we are speaking with another lovely and talented attorney, John D. Coyle Esq out of New Jersey, who has a little bit of good news to spread around this Christmas season. And that is a victory for firefighters who resisted the COVID-19 mandates in the state of New Jersey. Welcome, John. Welcome, Jennifer.
Thank you, John. Thank you, Jennifer. Good to be with you.
So, John, can you kind of give us the top line of your case and the background and the results?
Sure. I've represented many first responders during the COVID pandemic, and this particular lawsuit was brought by Greg Giordano and John Kozak, two firefighters with Maplewood Fire Department in New Jersey. Greg had been a firefighter for 24 years, and John was a deputy chief with 23 years of experience. These were the elite of firefighting. And Maplewood was one of the few municipalities in New Jersey that imposed a COVID-19 mandate. The state didn't mandate it. The state did for medical workers, but did not for first responders. But Maplewood jumped into this with both feet. And both John and Greg, amongst others, submitted religious exemptions, and John and Greg were denied. And after they were denied, the town engaged in what I think the only word I could call it is a Stalinist show trial. They were put on trial for discipline charges, and it violated every possible rule of due process or even known policies. They were supposed to have a trial by three chiefs. Instead, they were tried by the business administrator who denied them in the first place. They were denied the right to call witnesses. The town declined to present any witnesses, didn't respond to discovery, and presented no testimony except the business administrator who said, "This is what happened." And we said, "Can we question you?" And he said, "No." And then they were fired. And really, it's been a 4-year odyssey since then, proceeding on multiple tracks. One through the Public Employee Retirement Commission, PERC, trying to challenge this reversal on merits in discipline, and then a lawsuit that I brought in the District of New Jersey. That's the top line.
And John, what a similar top line it is, because I know we have a lot of first responders, we have a lot of police officers and firefighters watching us today. And what you're describing is what happened right here in the city of Los Angeles with what we call the sham boards of rights, where they put these firefighters on trial, basically didn't let them bring evidence, they literally in one of them said, "We don't want to hear that evidence today." And tell the audience also, in that show trial, wasn't it just one man who was wearing multiple hats?
Yeah, the town business administrator was the person who denied them, the person who presided over it, the only person who presented testimony from Maplewood. Actually, I was going to say the facts. The person who said what was going to be admitted and then declined to be cross-examined, declined their ability. He said, "I know I got served with discovery requests. I'm not going to respond to them." And then said, "And by the way, so you're now all fired." We had a separate hearing for Greg, and at the end of it, he fired Greg. And then we said, "All right, let's now do the other one for John Kozak." It's going to be the same result. Okay, fine. He's fired too. I walked out of this literally saying, like, I don't understand as an attorney, regardless of what you believe on merits or facts, I don't know how you could believe this takes place in the United States. Like, for such callous and almost intentional malice for the people who spent over 20 years jumping into burning buildings is beyond my comprehension, except at the time was behind my comprehension. But as we all know, and it seems to happen over and over all over the country. And this is the sad world we lived in.
Yeah, and in fact, you're right, because this is what I keep wondering is, where did that attitude come from? Why did that one business administrator, or why do the chiefs and the boards of rights here in Los Angeles, why did they think they had the ability to do this and no one was going to call them out? And thank goodness that you called them out, and that your plaintiffs, you stuck through this 4-year odyssey. And you called it a Kafka-esque proceeding. Really unbelievable, the abuses that were going on to reach these tortured results. We're seeing that across the country, which is why your settlement here is going to be two things. I think extremely positive for first responders who need to see that kind of justice, but also really frustrating, certainly here in the Ninth Circuit, where we continue to see dismissals and denials of justice. What do you think about the disparity over in New Jersey versus what's happening out here?
Well, I will tell you, New Jersey and California have a lot in common with respect to their absolute disdain in the courts for COVID cases and religious beliefs. I think that is a common theme across the board. I think this case was an outlier in some ways. Hopefully it's a start of a good trend in the right direction. We really pushed Maplewood on all of the disparate impact of this. It turns out that Maplewood would grant medical exemptions. Maplewood granted medical exemptions for firefighters and police officers, and they fired these two people saying they couldn't possibly be accommodated. While we pushed into discovery, the specific facts of this were Maplewood is in the process of merging with another town next to it, and the new fire department didn't have a COVID mandate, and the other town that was merging with them didn't have a COVID mandate. So that meant for a period of time, the firefighting rigs and the apparatus and the houses and everything else were staffed by people from South Orange who didn't have to be vaccinated, and Maplewood who were, or they weren't. They were saying they couldn't work safely with other unvaccinated or vaccinated people. And the truth is, I can't justify how somebody thought that this dichotomy ever made sense. How could you insist on the strict line that these people, and Deputy Chief John Coyle Esq wasn't running into buildings? He's the on-scene general. The quote from the current chief was like, if a deputy chief interacted with the public on a fire, it'd be 1 in a million situation. I can't imagine it. Right? This is not somebody giving CPR. Right. This is the general on the scene, and he can't work safely. Meanwhile, every other firefighter is working on a rig with non-vaccinated firefighters. One of the things we pushed up is not just that aspect of it, but the fact that there are emergency services agreements, where if there's a fire, 2-alarm, 3-alarm fire, the fire gets above the side, depending upon where that occurred, different agencies, different fire departments from neighboring towns respond. Well, they didn't have vaccine mandates. Right. So the idea that you could say, I have to fire this 24-year veteran because he can't safely be a firefighter unvaccinated, when in reality, if he was working there, half the people on his apparatus wouldn't be vaccinated. And if it was a big fire, he'd be intermingling with other people from other towns who didn't care if they were vaccinated. If you didn't live through COVID, you will never be able to ever understand that this is what we all went through. And yet this just became the normal all across the country. First responders, doctors, everybody.
It did. And what you're describing is that mutual aid situation that we saw, of course, here in California and in Washington State. In my Peterson case, where the Snohomish Regional Fire and Rescue Department is the hole in the donut, surrounded by departments that all accommodated their firefighters. So our surfer guys were repeatedly interacting on routine mutual aid calls with unvaccinated, with vaxxed and unvaccinated, mixing and mingling constantly. And we brought that up to the court. Courts out here don't seem to think that's important. The Ninth Circuit said that, well, we can't account for the decisions of other departments. No one is looking at the factual inconsistency of nobody was a danger here and you didn't think they were a danger. So That is inexplicable. Why that alone isn't causing these cases to be, number one, to stop summary judgment, and frankly, to stop even moving through the system, because that's ridiculous. You also had another really great issue, another point, in that they admitted the fact that they had medical exemptions and religious accommodations. Talk about the difference, the important difference between a medical exemption, a complete exemption, and an accommodation.
Well, I'll say first part is, you said admitted. They conceded this. I had to beat this out of them because this is one of those issues that defendants fight tooth and nail to keep from coming out. And I have made that the focus of all my cases. I drill into that in federal court and state court. And I've had to literally stand up and basically scream in court, like, you don't understand. If you have two clerks and one seeks a medical exemption from this mandate, and you say, okay, they can work there, and the person in the office next to them says, I want a religious exemption, and they can't work there, how can you possibly look at this and understand this? And slowly but surely, I've developed a body of case law. And then every time this comes up, I start citing all these other cases, like, this is how this works. And when you think about it, the disparate impact and the disparate treatment is the crux of so many of these cases. It's so hard to prove discrimination because very few people, although Maplewood may have pushed the envelope, very few people just come out and say, yeah, we don't like people with religious beliefs. We think you're fake, or all these other things. Instead, it's circumstantially trying to prove it. And how do you do this is when you have, what we argued is, when you have a firefighter and a police officer who say, I had an adverse reaction, so I need a medical exemption. And the town says, that's fine. And nothing is put in place for them. They just worked normally. They weren't even required to mask or test. They just operated. And at the same time, a firefighter who says, I want religious exemption, they can't be accommodated, even with masking, testing, everything else you can come up with the sun. And this happened. It defies reason how this happened, and yet it happened. So the crux of all my cases is to push for that kernel of information, because I know that, I believe deep down that when you push deep enough, you find it. And in the cases that we found it, after you drag it out of them, those cases do a quick 180 and turn 100% in plaintiff's favor, as did this case.
And so do you find, when you talk about undue hardship, of course, we got to look at Groff versus DeJoy, and the fact that Groff clarified undue hardship to make it really that much more difficult, a task for an employer to prove that accommodating a person's religious conflict with, in this case, COVID shots, accommodating them was going to have to pose a significant, excessive, unjustifiable burden on their operations. And I haven't found a defendant that can prove that.
No, and ironically, Groff was a reversal from the Third Circuit. So it was from a district, it was a Pennsylvania case, the Third Circuit, New Jersey, Pennsylvania, Delaware, Virgin Islands. But Groff, the Third Circuit case law was undue burden means de minimis, any burden whatsoever. And it got up to the Supreme Court in Groff, and the court said, hi, undue burden means undue in the course of the business, and burden as in something outside of anything normally expected by the business. The plain language of exactly what these words meant. And so it was a reversal in D&J. I will tell you that we're actually currently briefing right now an issue on this, because after Groff, the Third Circuit went back in and had a new case that came out in May, which was decided saying it's Smith versus City of Atlantic City, another firefighter case, not mine. A firefighter case. It was a religious exemption case for a person whose religious beliefs included a thick beard. He was a firefighter for like 25 years. And again, he was more like John Coyle Esq. He was not a frontline firefighter. And they said you had to wear this certain mask, and hey, it doesn't fit over the beard, so you're fired. And the district, New Jersey, said that's fine. And the Third Circuit said, well, in light of Groff, we're going to go back and change this, and reversed it. And we're starting to see the snowball, right? These cases move like glaciers and battleships. Groff is filtering through the districts. And in one of my cases, I mentioned this because I have a case for an employee who was fired for a vaccine mandate, and we submitted summary judgment briefing prior to that new decision from from the Third Circuit, and the court just got back to us this week and said, can you rebrief the impact of what the new standard from the Smith decision is? And I'll tell you the answer is, it's not good for defendants. So
Right.
The law is changing. Slowly.
Gratefully.
Yes.
Yeah, slowly but surely. And interestingly, you bring up the point about the beard. And we had a similar case in California, post-Groff, against California Department of Corrections. Back in the day, with the de minimis standard, you had religious Sikh officers or corrections officers who also wanted that exemption because they cannot shave their facial hair. Under de minimis, they would routinely be terminated. But now we've got the new post-Groff decision saying, not anymore. You cannot demonstrate that this one officer's beard is going to cause undue burden on your operations. But get this, that's beards. That's other areas other than the COVID mandate. And what we're seeing in the Ninth Circuit is they are ignoring Groff when it comes to COVID, quote, vaccination. And they are grasping any speculative and conjecture kind of hardship that an employer can dream up. And we're seeing that the employers are basically treating COVID-19 as per se undue hardship. So it was so great to see your result and the settlement for those two firefighters in the COVID mandate context,
Right.
because that is what we need across the country.
Yeah, and I know this is a frequent theme on Freedom Council, one that I echo 100%. I build all my cases towards affirmatively moving for summary judgment. As a plaintiff, people tend to play defense. You're trying to find what you can to throw stuff at the wall to defeat the defendant's motion for summary judgment. I flip it on its head, and I affirmatively look for the pieces that can build disparate impact, discrimination, different treatment outside of these. And in New Jersey State and Federal Court, I have 3 motions for summary judgment pending as a plaintiff on these exact same topics. And we need to change the paradigm and be in charge.
Are you bringing those on specifically on undue hardship, or are you adjudicating bona fide religious beliefs? What are you bringing them on?
I'm bringing them on the failure to accommodate.
Okay.
New Jersey has its own anti-discrimination law, the law against discrimination. In many ways, it's a lot broader than Title VII, but they overlap. The law against discrimination case law says, look to Title VII. So they fit together in a lot of ways, but the LAD is typically broader, especially when it comes to damages. There aren't any damages caps like there are in Title VII. So we typically focus on the failure to accommodate. And one of the things we focus on is trying to lock in the prima facie case of forcing the defendant early on to take a position that says that they don't dispute or didn't dispute their religious beliefs, and setting it up that now under the post-Groff world, the Third Circuit case, the Smith case I mentioned, the firefighter, they said on a failure to accommodate claim under Title VII, if we meet our prima facie case as plaintiffs, it goes straight to undue burden. And if they can't show the Groff standard of undue burden, they lose right there.
Mm-hmm.
A lot of the defendants are having to realize that by the time you got to this point, they took positions and their lawyers told them what to do 4 years ago, and they argued things in court based on de minimis, everything else like that. And now that's not the rules of the game have changed, and they're having a hard time retroactively keeping it up.
Are you finding, though, that are you getting any pushback from either defendants arguing this or judges pushing back saying, well, the things we know now are not relevant to what happened in the past? Or are you able to walk that line about saying, no, the things we knew back then were plenty?
I try to walk a very thin line for an intentional reason. The law doesn't favor plaintiffs. A defendant could find out 4 years into a lawsuit, plaintiff tweeted this, and that means they don't have sincere beliefs. Mm-hmm. And they're allowed to bring that in. And then on the flip side, when you try to argue, hey, everybody now knows that these vaccines didn't do A, B, and C, and all these things were lies, it's sorry, that was not in front of the employer at the time, so that doesn't come in. And I can understand on one hand how we got there, but on the other hand, it is entirely one-sided and unjust. So I do everything I can to try to steer away from that. As much as I can steer my cases away from that aspect of it, I tried to focus on what was going on at the same time. Example, I have a lawsuit for federal lawsuit for 10 employees of a hospital system. While they were hospital mandates before the CMS mandate, New Jersey had its own version, which then essentially mirrored the CMS. But almost every hospital in New Jersey allowed exemptions, and you had to mask and test and all those other things like this. Some didn't, and one of these was a place in Ridgewood, New Jersey, Valley Hospital, fired everybody. Mm-hmm. And one of the things we're pushing for in discovery is we've actually sent third-party subpoenas to the state's biggest hospital systems, asking for this report they had to file with the state as to how many exemptions they granted. And Valley is fighting this as hard as you can. And what we really want to point out is, did COVID work differently in Ridgewood than it did in Hackensack? I don't need to take on the science to say that you are wrong about this, when I'm hoping to, and again, that case is far from decisions down the road. The idea is that every other hospital system in New Jersey could accommodate tens of thousands of unvaccinated nurses, doctors, everything else. And if you worked at Valley, if you were the groundskeeper, you were fired. So the full reckoning of this is yet to be told. But the key to me is, and I'm not revealing secrets, because if you're in a case against me, we hammer you about this from day one, is how you treated somebody and how did other people treat it? Force them to defend it. Why did this work that way?
Mm-hmm.
John, you'd mentioned that discovery was rejected by the city.
Oh yes, at that hearing, yes. So at that hearing, there were discovery requests served in accordance with the Public Employee Relations Commission rules, and in fact, the union firefighter contract. I worked closely with the union lawyer who was representing them, and he served discovery requests for the hearing. The town said, "Yeah, we're just not going to respond to these."
Were they forced later to respond?
No, but they were forced even something better, which was they were forced to pay them back pay. They were ordered to rehire them. Maplewood decided not to rehire them. Going to take that out of the way. Then eventually, as part of this, not only did they have the lawsuit we had here, they were forced eventually by the state pension people to restore them full back pay to 25 years, give them a full retirement pension at 25 years, pay all the pension benefits, and then we went forward with the lawsuit. So in essence, Greg and John got close to full pay. They'll quibble with me that they got full pay, but they got full pay to 25 years. And then we got the lawsuit, and we collectively brought down over $1.25 million for the two of them.
Is it common for defendants to just ignore discovery requests?
In non-litigated matters, absolutely. We found that, I think it's a set of processes. When you're dealing with these public employee boards, like I'm sure they're in California, the towns are used to dealing with these like a union negotiation. They just keep saying no, 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 and eventually they win. And that happens a lot of times in these proceedings. These people were fired, but at the end of the day, eventually it became clear, black and white, that the process that they were written into the statute, process of their union contract, they weren't followed. And so that they were ordered to be reinstated, paid back pay to that point. And the town said, no, we're not reinstating them. And then another proceeding was brought, like, okay, here where we are. And then at that point, the lawsuit had been long moving along. We were deep in the lawsuit. And then, so the short, that's a long-winded way of saying, in non-litigated matters, the rules, the towns, municipalities don't feel they have to follow the rules. And in most cases, there aren't consequences for it.
Yeah, because the consequence is going to be, for example, in an agency decision, you need to go into court to challenge that decision. Do you have in New Jersey a similar law like our Skelly hearings and the Loudermill hearings, where the first responder, the employee, is entitled to a pre-deprivation hearing? And did you experience that being ignored, and then that forming the basis for reinstatement?
Yeah, so that was the hearing I was referring to, the show trial. That was actually the equivalent of a Loudermill hearing. We have those in New Jersey as well, but it was a specifically narrow one just under that contract. So for the firefighters in that position, it was the equivalent to the same thing.
We have found out here in Los Angeles, it's bizarre that the judges have granted back pay for the time where there was no pre-deprivation hearing. They've granted that back pay, and they refuse to grant reinstatement. And we just saw that in the Superior Court in the Michael McMahon case, a police officer, where he was terminated for not signing off on a notice where he was supposed to agree as unvaccinated to pay for his own COVID testing on his own time, which at that time was an illegal demand. And he was granted back pay, but no reinstatement, which is strange because everything that flows from that illegal action he should have been made whole. But we're not seeing that out here.
No, and I guess I'd say more technically, the first order from the Public Employee Relation Commission was you have to pay them back pay and then either bring them back or follow the process for disciplining them correctly.
Right.
I suppose the town could have done that, but at that point, they'd already lost because through the lawsuit, which is going on in parallel through all the discovery, things that they couldn't possibly defend it again. And so they were sort of stuck in the middle of this, which is like, we're ordered to either pay them or bring them back or discipline them. I don't think we can discipline them again because of the record we've now developed in the lawsuit. And end of the day, the town gave in. And it's really sad to think of the towns really used these competing public hearings, public processes and lawsuits against each other. I'll say in this case, the town kept saying for years, dismiss the lawsuit and we'll bring you back. And the impact of this, we talk about this in the abstract, but what it really is you have people who haven't been paid for years, who haven't collected their pension. So you're a 24-year firefighter, you've been paying into this, and now you're not getting a salary, you're not getting a pension check, you're not getting benefits, and you're forced with the question, which is, do I try to retire early to collect something to do this and cut benefits down for the rest of my life just to stop the bleeding? These two brave firefighters, it's redundant, every firefighter's brave, but these two brave litigants stuck to it and said, we're gonna make this as best we can. And I'm glad to have been able to fight for them this way.
And what would you say, I hear this a lot, what would you say though to people who say, why couldn't they just get another job? Why couldn't they just go next door and get another job? How easy is it for firefighters, especially the most experienced, to lateral into another department?
I'll tell you how it is in New Jersey. You can't.
Right.
Your seniority, your leadership, your position, every aspect of what you've accrued, you actually can't carry through to another department. So they could have conceptually applied to be probationary plebe firefighters at another town. After being the deputy chief with 23 years of experience is now going to go back to the academy to prove that they're a probationary fire department. And in doing so, the consequences of this would be staggering. They would alter their pension structure. They would alter their pay scale. You would essentially moot this whole proceeding that says, you can't discipline me illegally. I guess I'm going to start over and move to a different town and cut my salary in a third and then have no seniority. And, God forbid something actually happened to them. Right. Your disability is based on your last year's ratings. If you work for another town at a third of the pay and, people who run into burning buildings are the most obviously able to be hurt for anybody. You ruin yourself and your family for the rest of your life. So the answer is you can't just move somewhere else. If you fire me as a lawyer, I could try to get a job somewhere else. You fire a firefighter, you've ended their career.
Right. We've had that happen to so many people.
How do your clients survive when they're in the middle of this limbo between firing and litigation success?
Very difficultly. I do know that, we all talk about the legal aspect of this, but the real life consequences on these people are often overlooked in court as just hand waved and moved past. Yeah. I'll say this, Greg Giordano had to sell his house. He lived with his wife and their adult daughter. He had to sell his house because he couldn't afford to live there. North Jersey is not the cheapest place. I know I'm speaking to people in California, so we're all speaking the same world. He couldn't afford to live there. He had to sell his house he'd had for 20 years and move to a rural area where he was outside of his friends, family, loved ones, his children, and just try to get by. And the pressure and strain on people's marriages, psychologically, the consequence of just like not getting paid. How many of us could just not get paid for 3 years, right? Like, no. And if you're steadfast and these are what you believe in, and this is what's right for you, and you believe in your rights, and you want to fight for it, a lot of people can't make that decision. I don't begrudge anybody. The same way a lot of people gave in and got the vaccine. I said gave in, that's judgmental. But a lot of people had to deal with the fact of like, I'm a caregiver, I'm a parent, I've got 2 young kids, I provide health care for my wife and kids, and somebody's sick, somebody's disabled, somebody else like this. I can't not keep my job. And I've counseled people back then about it, and you say, listen, I know. I can't even, you couldn't even tell them in 2021, 22 that stick the course, it'll work out for you, because it just doesn't. None of us knew what this law, we all knew what discrimination law was, and we all knew how it was. And it seemed like A to B, it applied to COVID, and yet it didn't. Right. And was that just a blip? Was that a Korematsu blip? Right. And for those non-lawyers who are listening, back after Pearl Harbor, the United States decided to internally deport all first, second, and third generation Japanese to camps in the desert. And went to the Supreme Court in the case Inri Korematsu, and the Supreme Court said, that's fine. And then 70 years later, the court said, yeah, I think we got that one wrong. Go back, we got that wrong. It took 70 years to reverse that. If you've lived through 9/11, I worked in New York City at the time, graduating law school, you saw rights eroded that we still haven't gotten back. We voluntarily did this to ourselves with the Patriot Act. And when there's a big enough, you scare people enough and you can take away their rights or persuade them to give them away. And persuading them and taking them back is awfully hard. And I know that this is something we fight out at the Freedom Council, not just on COVID, but all these aspects of this medical freedom, the idea that you can even make decisions for yourself in a hospital or your loved ones, things that seem so baseline fundamental to our human existence. We've had to claw for every step of the way. So bring it back. How do they get by? Because they actually believed in this. John and Greg believed in this. And if you feel your answer, you are following a higher calling on this. God doesn't always make the path easier for everyone. Those of us who are believers know that. And they persevered.
Well, as an attorney too, how do they pay you? That's been a big thing for a lot of the litigants or potential litigants that I meet. Everyone's desperate. They're looking for attorneys willing to take these cases, but the cases are fraught with risk on your end. If you don't win, you lose everything, and everybody then is penniless afterwards.
That is
even
correct.
Though it's highly unfair.
These cases were taken on a contingency basis. I can't. I'd love to have somebody who just got fired pay me nice hourly wage, but I can't tell them that the only way I can get you justice after you got fired and cut out of everything is to liquidate everything you have just to try to get back to square one. But you're right. So the answer is that I don't consider myself brave. I consider myself I didn't have an option. This is like many people I know you see. I had a nice cushy law firm job until COVID. I was head of litigation for a boutique law firm, and when COVID came around, I said, I gotta go, because I need to not have to. Big law firms don't like taking these cases on plaintiffs because they don't like not getting paid hourly, and they like to be the one representing the hospitals in the towns, not suing them.
Right.
But my wife was 100% on board with me. This is not a new area for us. Prior to COVID, I represented nurses in connection with vaccine mandates for the flu. New Jersey had a flu vaccine mandate. And I'll say this is one of the most ironic things I think about, which was one of my last flu vaccine cases pre-COVID. We had a nurse who had religious beliefs and against flu vaccine, against vaccination. And the hospital was trying to work with the EOC for an accommodation for her. And I said, we said, look, during flu season, she'll wear a mask and test for the flu every week. And it's a several month window out in the East Coast here. And the hospital's like, wear a mask for 3 months? That's absurd. No one would ever agree to possibly wear a mask for 3 months. And because in 2019, that was absurd. The
Right.
idea, they thought I was joking. Like, what do you mean she'll wear a mask? Like, these are her religious beliefs. This is what it takes. And then fast forward a year, and then everyone's been bubbled up for 3 or 4 years after that. And what became absurdly ridiculous became the norm awfully quickly. So my wife was firmly with me, and we left and started this. Left and started this firm, and then I haven't looked back. And while COVID litigation is petering out somewhat, I still have a lot of cases. I still have a lot of cases. I have a lot less coming in than I used to. I still have cases for this.
But John, don't you think that the fewer are coming in, of course, because everyone's statute of limitation is evaporating with every single day?
That's right. And, we tried to drill out as quick as we could, like, hey, folks, there's time limits for these claims. You got to get these out of the way one way or another. Yes. But vaccine discrimination, I'm still filing new cases. I'm still filing new post-COVID vaccination cases. I'm finding that companies are still finding ways to discriminate on vaccines long after COVID. You think, like, when you touch a hot stove, you learn not to do it again. Some of these places just got to keep touching it and just got to keep doing it.
Well, we're glad you're doing out there in your circuit, because we've got a problem in the Ninth Circuit, and that's with my case Peterson in the Ninth Circuit, where the Ninth Circuit has affirmed the ability of the employer to basically just say, yeah, COVID's the problem, or the disease du jour is the problem.
That's right.
And we can then tell our employees, well, if you don't have X shot, then you are a risk and you have to go. With no other evidence, no burden, no operational problem, no nothing. That's the situation now out here in the Ninth Circuit. And that's a problem for the nation that I don't think enough people realize. So we've got to get that one to the Supreme Court.
We sure do. I will tell you, I think some cases from the East Coast are making their way to the Supreme Court now, some very quickly. And I think that this is being addressed. But the one thing you just hit upon is the critical reason we do this. I know, plug again for Freedom Council. This isn't about COVID.
Right.
This is about COVID, but it isn't about COVID. The rights that are being taken from everybody and the normalization of discrimination can't be allowed to continue. And it's only by fighting COVID vaccine issues that we really get to the heart of everything else, which is, you have rights and you have beliefs, and the government can't take them away just because they feel like it. You said the disease du jour. Sure, COVID now, COVID B, COVID C, pick your pick of what the next catastrophe is going to be.
Or even not a catastrophe. What about?
I was going to say catastrophe, right?
Yeah.
No, this is the people like you. We talk weekly or almost every weekly on these things. You need to fight this, and even when it's we need to make the courts understand that this isn't just, persuading a judge who I'm going to say 99% of the time is very vaccinated, went through a court system that required them to be vaccinated and resisted going in person for court stuff for a lot of reasons. Persuading that person that, no, this is not about you being wrong about COVID. This is about something bigger. Is not an easy task, and it's not something you can persuade all jurists. You don't leave yourself at the door when you put on the robes. You wish you did, and some judges do a better job of this. But I'll tell you, back to this case of Giordano and Kozak, I had been asking the judge for a settlement in a summary judgment schedule. I made clear I'm moving for summary judgment. I don't care if defendants do. I'm going to win. And the judge essentially asked us to mini brief it, and we sent a mini brief. That said, these are the points, and this is going to be the basis of my motion. And this judge, to his credit, Magistrate Espinoza in New Jersey, had his clerks brief it. His clerks write memos and be like, if he's right, does he win? He didn't share the bench memo with me, but I will tell you that he pulled the defendants into the settlement conference and said, tell me what he has wrong. I'm used to the other side, which is when we have settlement conferences, the judge drags me in a conference room to yell at me to tell my clients to lower my client's demand. This time I'm sitting in the courtroom. My clients go, is it normal that the defendants are in there for 3 hours? And I go, nope, but it's a good thing. And
How you mentioned something earlier that social media posts from a client may remove the belief that they have a sincerely held belief. Are people of faith not allowed to have a sense of humor?
I think people of faith need a deep sense of humor to have gotten through the last 4 years.
Correct.
But you're right. I mean, listen, in concept, I'll say the following. I don't want this to be used against me by anybody who tries to cite this in court against any argument I'm making. If this was a case about whether there was a car crash and the light was red or green, right? If I said it's green, and then later on I keep posting memes saying like, man, I love red lights, all these accents, I can conceive it's probably an awful example, but I can think of situations where something after the fact could alter your perception of what they said in the first place. If you're on trial and somebody wants to attack your credibility for truthfulness, the fact that you were charged with fraud years later could be relevant. But when you're trying to judge somebody's religious beliefs, it's almost inconceivable that you should be able to do it the way the courts have allowed it.
Mhm.
Right.
I'll just speak for myself. My journey of faith has evolved over the years. And where my family is now is not where we were not that long ago.
Yeah.
And how, if I was to write all my beliefs out in a straight line every couple of months, they change.
Mhm.
The fact that now I have a Bible on the side desk next to my phone in my office doesn't mean that I didn't have beliefs when I didn't.
Mhm.
And I feel it's just so unfair and anathema to what religion is. God meets you where you are, and people's beliefs, it's overdone to say there's no atheists in a foxhole, but that doesn't mean those people didn't believe before they got in. And if you pretend we're not talking about looking into someone's soul and their hearts, I can understand in concept why you're questioning people these ways. But it has become a hammer for defendants who discriminate against people with religious beliefs. And some of these defendants, when they're pushed, they absolutely do that. Maplewood, for example, has rainbow crosswalks at the town hall. They have rainbow crosswalks and they have signs saying, we're a stigma-free town. We believe in rights and everything else like this. And then they turned around and fired everybody who said they had religious beliefs. And they don't think twice about it. Mm-hmm. And I bet they do it again. Maybe less after paying my clients. But they would only reluctantly not do it because they have no problem mocking people with beliefs while believing all sorts of other things. Yeah.
Were you able to identify within Maplewood the actual, I don't know, cheerleaders of this policy, the people that really pushed it through over the others? I love the name and shame. It's my favorite thing.
Well, Jerry Jimes was the name of the business administrator who was the person at the show trial. He's named to my complaint individually because the law against discrimination allows you to serve people who aid and abet discrimination. So I directly targeted all of them. I targeted the chief, Alvarez, and the business administrator who was the man behind this, The irony is, I don't even know how deep the root of discrimination goes in Maplewood. I have, we joke that we have in this firm a Maplewood practice area. I have a lawsuit for a police officer disciplined for being a whistleblower. I have a lawsuit under the Crown Act for a black female police officer who was disciplined for wearing her hair in a traditional black hairstyle, and the two sergeants who were disciplined for not disciplining her. So you want to ask yourself, hey, why did you put those rainbow crosswalks up if you are going to have just such systematic, broad-based discrimination any which way you can get it? I really don't have a good answer for this, but I do think this is like one of those roots that you just can't rip out of your lawn. You think cutting a check for $1 million for my clients might have helped do this, but no.
So is it possible in future litigations that you could also request these city leaders be educated on religious tolerance?
Sure. I will
to change a culture.
Yeah, injunctive.
Listen,
I mean, they do it for all these other things. Why not? DEI gets tons of them.
Yes, they do. But DEI and racial discrimination are treated differently in people's minds than religious discrimination. If you tell people you fired somebody because they were a pregnant woman, everyone's outraged and they say, well, you need to not do this. If you said you fired somebody because they were African American or blue or green or an Eskimo, whatever you want to call it, people see that as discrimination. For whatever reason, people don't see this the same way.
John, that's a great question. I want to jump in and ask you this before we have to wrap up. And here it is. It's the public perception.
Yeah.
You've been filing these lawsuits even before COVID, and you filed this one in 2023. And I want to know, can you feel a change in the public sentiment towards these cases that we're hoping will ultimately be the societal change that gets the courts to change? Do you feel that having changed?
Yes, and I'll tell you why. I told all my clients back in 2021 when they were fighting to keep their jobs, and I was fighting to keep these guys' jobs back in 2021, 2022. I told all of them the following. Your lawsuit is going to be in a box here. In 2 or 3 years, when your lawsuit's at a meaningful point, either we're going to have stacks of dead bodies in the road from COVID, or we're not. And if you're one of the people who believes that this is not what's going on, what's really happening, let's wait it out. And the cases, you sort of played a waiting game. The EEOC has a nice feature of delaying things by those procedures that ultimately go nowhere, but it's delaying. Anybody who got to court in 2021 lost across the board.
That's
Anyone who got to court in 2022, they were falling dominoes by the wayside. Motions to dismiss were being granted. Everyone across the country. The further you got away from COVID, it started slowly sinking in that maybe we're lied to. That's not a legal argument, but I believe it's in the backstory of this, which is that if that's a big lie, how long are we going to perpetuate it? And I have found that for the people who've been able to kick around, or those who lost in 2021 and are being reversed and are having those dismissals reversed by the appellate courts. This will go to the Supreme Court. The idea that when Groff came down, it was like a ray of sunshine from the sky.
It was a landmark. I mean, it was tectonic.
All the lawyers who've been doing this have been saying for years, discrimination. You can't say undue burden for a discrimination case for medical ADA, a disability combination, means undue burden all over the place. But for religious, it means it's the peppercorn from the contracts class in law school. That cost me, I got to buy a mask for somebody. It cost me 39 cents. You're fired. And it made no sense. And it took too long for the court to be like, hey, by the way, this is wrong. And I think in the next year, 2 years, we are going to see all this cemented and walked back. It won't take the 70 years Korematsu took.
And hopefully not the 50 years it took for Groff to finally get it. That we don't have that kind of time to wait, for sure.
No.
Yeah.
So
thank you for being one of the ones
Yeah.
out there doing this. Appreciate
Thank
it.
you, Jennifer, for bringing me on. It's a pleasure. And it's a real great idea when we do our weekly brainstorming sessions at Freedom Council to talk to people across the country and what are you doing? What's working? What's not working? What are you seeing? What are your strategies? And it just, all of us are better for doing it.
It's a great collaboration. Yeah.
Thank you for taking the risk on this case, John, and pushing through for your clients.
Anytime.
And congratulations to them. They must be over the moon.
They're ecstatic.
Yeah, they deserve it.
Ladies and gentlemen, that should be it for today's show. Thank you, everyone, for watching, and we will catch you guys again next week. Happy holidays and Merry Christmas.